Good morning, everyone. Welcome to today's class. Uh, I'm your facilitator for today. For me, Ohana, I will be taking business law, registration of business, and compliance requirements. So, in today's course, these are the things I expect participants to be able to learn today. So I expect participants to have a basic understanding of the nature of the legal system in Nigeria. By the time we're done discussing the legal system in Nigeria, you should have a basic understanding of that. Enable participants understand the legal regime and regulatory agencies regulating businesses in Nigeria. We'll discuss the various regulatory agencies regulating businesses in Nigeria. Then for participants to know the types of business organizations, you should be able to know the different types of business organizations and steps in the formation and registration of businesses in Nigeria. Then for participants to know the different Okay. Sorry. Sorry for the technical problem we experienced. I don't know what happened. I just suddenly disappeared from the meeting. So I'm sorry about that. So as I was saying before the sudden interruption, we're going to look at these are the objectives to understand the basic nature and elements in a commercial contract. Then what are the topics that we will be discussing? First of all, the first topic we will discuss is the Nigerian legal system. Then we will discuss the relevant government agencies regulating business in Nigeria. Then types of business organization and legal implication of the various types of business organizations. Then registration of business organization. Then finally, we will discuss law of contract. So let's discuss the Nigerian legal system. When we are talking of the Nigerian legal system, we are basically talking about the totality of laws, rules, legal rules, and legal machinery which are obtained within Nigeria as a sovereign country. So when I say Nigerian legal system, I'm talking about all the laws we have in Nigeria, all the arms of government, the judiciary, the executive, and the legislature. I'm talking about all of them. Then I'm talking about the when you come to the executive arms, we have various ministries, parastatals that are there to implement the policies, the police, everything. So basically, when you talk of the Nigerian legal system, you are talking about the laws that are in place, the courts that are there to interpret the laws. Then you are talking about the various agencies of government that are there to implement the law on behalf of the executive arm of government. So basically, this is just totality of the Nigerian legal system, the courts, the correctional service, everything, the laws. So basically, this is the Nigerian legal system. So having talked about the Nigerian legal system and you have a knowledge of what the Nigerian legal system is now, then what is law? There is no single definition of law. As you can see, it means different things to different people. But basically, in our communities and families, we have rules and regulation, laws that govern our day-to-day activity. So that is definitely the understanding of law everybody has, because in every society, every organizations, they always have laws governing how they run that particular society or organization. So but for the purpose of this class, we will look at the law, the meaning of law to a lawyer and the law profession in the narrow and guarded meaning as rule of human conduct, tacitly or formally accepted by people as binding and backed up by some mechanism for the sustenance of its binding nature. So once it is there to regulate human conduct, tacitly or formally accepted, that means people must have by over time or formally come together and say, okay, this is what we want to govern our relationship with various persons in the community. This is what this law we're talking about, this set of rules that we've come up with. We want it to, we formally accept these rules to be binding on us. So by doing that, you've created a law that is binding on you. And that law will not exist in vacuum. There must be institutions that are there to, or persons within that society that are there to enforce that law. That's why there must be a mechanism for the sustenance of its binding nature. For instance, now the Constitution of Nigeria, we Nigerians have formally accepted that we want that particular constitution to be regarded as the Constitution of the Federal Republic of Nigeria. That is step of formally accepting the Constitution to be binding on us. So there are mechanisms there in place. That's why we have the executive, the judiciary, and the legislative arm of government. They are all there to ensure that this constitution is sustained over time. That is why if you have laws too, you have agencies that are there to enforce such laws, because such laws cannot exist in vacuum. There must be something to implement them. Then we'll look at the sources of Nigerian laws. These laws, they don't just fall from the sky. They must have emanated from somewhere. So when we talk of the sources, where did we get our laws? So first of all, Let's look at the Receipt English law. When we are talking about the Receipt English law, we are talking about the common law and doctrine of equity. These were laws that were brought into Nigeria when the British came to Nigeria to colonize Nigeria back in the days. So they came with their own laws. So for easy administration and for them to impose their will on us, they brought this law and they are regarded as the English receipt law. For instance, the common law is basically law on the customs and traditions of the people of England back then in the realm, just like we have our own customary law in Nigeria. So the people of England too, this common law is basically their customary law and traditions that they came and imposed on us. So back then in England, before the Norman conquest, there was no common law. Every community had its law. So what the king does then was to send out itinerant justices. So what do these itinerant justices do? They will go out to communities and administer justice based on the custom and traditions of that community. So once they administer justice based on the custom and tradition of these people, of the people of that particular setting, they will come to the capital, the crown. They will come and sit down and discuss. Okay, I've been to this community. This is the law I experienced there. This is the law they are practicing, and I think I like that custom. Sorry, they will discuss the customs and tradition. The good ones, they will sit down and bring them together. So over time, as they kept doing that, then evolved what we call the common law. So it's this custom and traditions that evolved to become the common law. And the common law is administered by the common law courts in England. So over time, the common law was administered by the common law courts of England, and then it became more concerned about form and procedure rather than administering justice. So, for instance, rather than looking at matters on their merit, the common law became more concerned about whether you followed a procedure of instituting an action or not. Procedure, for instance, if they say if you want to sell a car, it must be in writing. So under common law, if you fail to put that in writing, then you cannot get justice, even though you've paid for the car if the person refused to give you the car. So common law became so rigid that it's all about form and procedure rather than administering justice. So to litigants that are dissatisfied with the judgment that was passed by the common law court will petition the crown. And then if you petition the crown, it was the King's Council that will entertain that petition. And the King's Council comprises of the Chancellor. So as a result of that petition evolved the doctrine of equity. So when we talk of doctrine of equity, we are not talking of equity as in fairness. We are talking of the law that was developed by the Court of Chancery back then in England, by the Chancellor, to mitigate the harshness of common law. I said common law became more concerned about the form and procedure rather than administering justice. For parties that are dissatisfied, they began petitioning the crown. So the chancellor will now look at the merit of the matter. If you fail to follow a procedure, the chancellor will just overlook it and will look at the matter based on its merit and give you judgment. So that's why we have maxims like he who comes to equity must come with clean hands. He who seeks equity must do equity. So all these maxims evolved as a result of the doctrine of equity. So we have the English receipt law, which comprises of the common law and the doctrine of equity, and they are still applicable in Nigeria as we speak now, because some of the laws we have were influenced based and were made based on this common law and doctrine of equity that we have. Then we have the Nigerian legislation. It's another source of Nigerian law. This is basically the mode in which we make our laws in the 21st century and in the year 2020. And for instance, the new KAMA that was passed into law recently, the KAMA 2020, is a product of legislation. The ICPC Act is a product of legislation. The EFCC Act is a product of legislation. These are laws that are made by the National Assembly, assented to by the President. So for every law we have in Nigeria now, they are either made by the National Assembly or House of Assembly based on the circumstances and situations that warrant making of such laws. For instance, the CAMA that was recently passed and the Bank and Other Financial Institution Act that was passed to 2020 are product of legislation in Nigeria. So it will pass through first reading, second reading, committee reading, and the rest. Then final reading, then the president they will take it, they will pass it into law, they will take it to the president to assent, then it will becomes a law in the country. So most of the laws we have right now in Nigeria are product of legislation. Then we have the customary law. When we are talking of the customary law, just like the common law in England, it's basically the custom and traditions of the people of Nigeria, of that particular setting. So it's a body of rules regulating the day-to-day activities of people of particular setting in Nigeria. So the customary law, there are some customs in Nigeria that have become so notorious that they are judicially noticed by court. So once they go to court, you don't need to prove anything. The courts already know that this particular Nigerian custom is notorious. For instance, is the Benin customary law of inheritance. We know that if a father dies, his first son, his first male child, is the one that will inherit the house he's living in. He was living in before he's dead. So in that situation, you cannot, the court, once you tell the court that you are subject, when your father died, he was subject to the Benin customary law. The court automatically knows that you, as the first child, first male child, or any first male child in the family, is entitled to the house of the father, the house he was living at the time of his death. So these are customs that are still applicable in Nigeria, even though they are not codified, but they are still administered in Nigeria. And mostly when you go to these customary courts, you find out that the people administering or sitting as judges in those courts are people who are knowledgeable in the customs of the people of that particular locality. Then we have case laws. As I said earlier, the Nigerian legislature, they are the ones that make the law. The Senate, the House Assembly. But guess who interprets the law? Is the courts. So sometimes this interpretation by courts will be regarded to as law. They become case law. So they become case law in the sense that if if a particular section in a law is not understood, it is taken to the court for interpretation. What the court interprets it to be, especially what the Supreme Court interprets it to be, that becomes the law. That's why it is common for you to hear lawyers citing in the case of so and so person, the Supreme Court decided that. So you get it. So this particular decision becomes a law, even though it's an interpretation, but it's regarded as law because the court has made pronouncement on that particular section, and this is what the court thinks it is. So when we talk of precedent, judicial precedent, the Supreme Court is the highest court of the land. So once the Supreme Court decides on that particular matter, it becomes the law of the land, and all other courts in Nigeria must follow that decision of Supreme Court. That is why we have judicial precedent. When we are talking of hierarchy of Nigerian courts, we will still talk more about this judicial precedent. So then we have the international law. When we're talking of international law, we're talking of law that governs relationship between different countries. So we have different international uh, convention, customs that are there for different countries to domesticate. For instance, if you check the chapter 4 of the Nigerian Constitution, which has to do with the fundamental human rights, it's basically the United Nations Declaration on Human Rights. You get our chapter 4 of Constitution, and they have if also part of the African Charter. If you check, these are laws, international laws that influenced our own constitution based on uh, adoption that was made in the UN and the rest. And there are other laws too that we've domesticated and they form part of our laws. So if you look at these sources now, you get one way or the other, these sources combine to form our laws in Nigeria. So let's look at the hierarchy of Nigerian courts. the apex court of the land is the Supreme Court. The Supreme Court is the highest court of land. That is why when you hear election matters, let's say governorship goes to the Supreme Court, and they said the Supreme Court have decided that this person is the governor of so state. For instance, Imo, when the Supreme Court decided that the PDP candidate wasn't the governor, that is the APC candidate that is the governor. The PDP cannot go to any other court because the Supreme Court is the Supreme Court of the land, is the apex court of the land. Once the Supreme Court gives a decision on a matter, it becomes final. There is nothing you can do. You just have to take it the way it is. Then after the Supreme Court, we have the Court of Appeal. The Court of Appeal is second to the Supreme Court. So all matters coming from courts of superior records, they go to the Court of Appeal. From the Court of Appeal, they go to the Supreme Court. Although there are some election matters that will finish at the Court of Appeal, like National Assembly and State House of Assembly, they don't go to Supreme Court. They end at the Court of Appeal. Then we have the Federal High Court. The Federal High Court used to be a revenue court, but by virtue of Section 251 of the Constitution, so one paragraph F, you will see that in that particular section, the Constitution listed out the jurisdiction of the Federal High Court. That is matters that can be entertained by the Federal High Court. They are contained matters like matters between companies, matters that involve CAMA, CAC and companies, matters that involve patent, trademark, offenses that are federal nature. These are things that can be entertained by the Federal High Court. Then we have the state high courts of various states and that of the FCT. They have unlimited jurisdiction on criminal and civil matters, but they cannot decide on matters that are exclusive to the Federal High Court. They can only decide on matters that do not fall within the purview of the Federal High Court and that of the National Industrial Court. But as for any other matter and Sharia court matters, as for any other matters, they have the jurisdiction to entertain such matters. That is the State High Court. Then we have the National Industrial Court. As the name implies, in the National Industrial Court. The National Industrial Court is there to adjudicate on matters relating to trade union and labor matters, master-servant relationship, employer and employee relationship. So these are matters that are strictly within the jurisdiction of the National Industrial Court. Then we have the Sharia court that is meant to adjudicate on personal Islamic matters of persons who are subject to Islamic law. They will submit themselves to Sharia courts. Then we have the customary courts. As I said earlier when we were discussing customary law, the customary courts are there for the purpose of the customs and traditions of the people of that particular locality. So they administer matters based on the custom. The custom of the people is this, that is what the customary court does. It applies the custom. So the customary courts, area courts, they have similar jurisdiction. They all adjudicate on customary matters. It's just change of nomenclature. Area courts in the north, customary courts in the south. Then we have the magistrate court. The magistrate court is a court of inferior record, just like the Sharia court, customary courts, and the magistrate courts. The magistrate courts, however, have jurisdiction to entertain civil and criminal matters. So magistrate court in the north, they will tell you magistrate court, district court. It's just change of nomenclature. But they have jurisdiction to entertain criminal and civil matters. But though their jurisdiction is not unlimited, the subject jurisdiction and there is monetary jurisdiction. It's not all matters that you take to magistrate court. It's not all matters that you take to magistrate court. You first of all consider the subject and the monetary jurisdiction. Is it within the jurisdiction of this court? So basically, this is on the hierarchy of Nigerian courts. So let's quickly look at the laws, the civil law and the criminal law. And when we talk of civil law, we're basically talking of it serves to regulate the conduct of persons in their interpersonal dealings with other persons, conferring status, rights, and obligations on individuals or juristic persons. So when we are talking of civil law, it's basically between you and your neighbor. Civil law has nothing to do with the state, it's just between you and the neighbor. When your neighbor transfers on your property, is considered as civil law, it's not criminal. It's not of criminal nature that he will go to jail. Because offenses of criminal nature are the ones you go to jail, and they are usually written down that okay, if you do this in breach of that is criminal in nature and you are going to jail. And by virtue of section 35 sub 11 of the 1999 constitution, it says for anybody to be punished for an offense, that offense must be written, and it must be written and punishment must be prescribed. So any offense that is of criminal nature, it must be written. So that's why we have the police, the FCC, the ICPC, the Ministry of Justice, because Advanced Fee Fraud Act, Yahoo, you have some acts that are related to to corruption and the rest. That's where you see the EFCC or the ICPC taking over such matters. Murder, you see police coming in. Sometimes you see Federal Ministry of Justice, because these are offenses that are criminal in nature. However, when it comes to civil law, it's just contracts. You borrowed money from somebody, you entered into contract to supply him something, you failed to do that. These are offenses that are civil in nature and does does not entail you going to jail. So example of some civil wrongs are defamation, where you defamation can be slander or libel, where you publish a false statement about somebody. Then we have trespass, where somebody is in exclusive possession of a property and you decide to disturb his possession. So all these things are there. So having discussed the Nigerian legal system, let us look at the various regulatory agencies in Nigeria. What are the relevant regulatory? There are various regulatory agencies in Nigeria regulating business, but for the purpose of this class, we'll just look at some. One of the agencies we'll look at is the Corporate Affairs Commission. We'll discuss that in detail later. Then we have the Federal Inland Revenue Service and the various states' internal revenue service. We'll also discuss that in detail later. Then we have the Central Bank of Nigeria. When we talk of the Central Bank of Nigeria, we are talking about the apex financial institution of Nigeria. It is the bank of last resort. It's the bank of bankers. So the CBN is there to roll out policy for other financial institutions. It's the CBN that will give out policy on how to manage the Nigerian economy. That is why we have, if you have any problem, if there's problem with the economy, anything, CBN has to do whatever it has to do to ensure that the financial system is running smoothly. The CBN Act was established by the CBN Act of 1958. However, the current legal framework, the current act regulating the CBN right now is the CBN Act of 2007. So CBN is there to roll out general policies for the purpose of growth of the Nigerian economy. That's the role of CBN, to ensure that the Nigerian economy is growing. That is why recently you will see various projects by CBN. Even though, in my own opinion, I feel some of the projects carried out by CBN, they are stepping into functions of other ministries of government and the rest. See, that's the present agricultural scheme you are undergoing training for is one of the schemes by CBN to ensure that the economy is moving fine. Then we have the Asset Management Corporation of Nigeria, which is the AMCOM. The AMCOM is established by the AMCOM Act of 2010, though the act has been amended in 2019. Basically, the function of AMCOM is to ensure the flow of the cash in the Nigerian financial institution. So AMCOM is there to ensure that all those toxic debts, non-performing loans that in banks, that when we are talking of bad debts, non-performing loans, we are talking of loans that people that have borrowed loans from banks are unable to service those loans. Let's use an example. Let's say there's this company called Johnson and Johnson Limited, and Johnson and Johnson Limited approached a Guaranteed Trust Bank, when they approach Guarantee Trust Bank, they borrowed money from Guarantee Trust Bank, right? On the basis that they will pay the loan within 3 years. But unfortunately, Johnson and Johnson Limited were unfortunately unable to service the loan. So what AMCOM will do, AMCOM will call for the balance sheet or books of GT Bank to see, okay, which of the loans are not performing, which of the loans. So GT will show them, okay, this Johnson and Johnson borrowed 100 million from us, and they are unable to service the loan. So what AMCOM will do, AMCOM will say, okay, we are going to pay off that debt. We'll buy the loan from you. We'll pay you your money, the money that was borrowed by Johnson and Johnson Limited. Then we will go after Johnson and Johnson Limited. So by AMCOM doing that, AMCOM is ensuring that there is liquidity flow in the Nigerian financial sector, so that cash will not, banks will not be cash strapped. So let's, for instance, now if banks don't have money to loan out, for customers to come and withdraw their money, then there is problem. Because let's say everybody will decide to go to GT Bank now and say he wants to withdraw his money, then the bank will experience problem. So that is what we have Asset Management of Corporation of Nigeria there, for the purpose of ensuring that there is liquidity flow in the Nigerian financial sector. Then we have the National Agency for Food and Drug Administration Control and Control. We discussed that later subsequently in our discussion. We'll discuss it in detail. Then we have the Standard Organization of Nigeria. We'll also discuss that subsequently in detail. Then we have the Federal Development Authority, or the State Commissioner for Lands and Local Government Council. So basically, if you are into a business that warrants you using land, or you need to get allocation to construct a factory, to construct a warehouse, definitely you have to approach, if you are in the FCT, the FCDA, for allocation and the rest. So that's basically why we have this here, because there are some businesses you need permit from either FCDA, or if you're in other states, the State Commissioner for Land or anything, for you to use that place for a particular business. So let's quickly look at the Corporate Affairs Commission. Why why is the Corporate Affairs Commission one of the agencies responsible for regulating business in Nigeria? If you want to start a company in Nigeria, or if you want to register a business name in Nigeria, an incorporated trustee, that is NGOs, churches, and the rest, if you want to get the bank account, everything, the first point of call is the CAC, the Corporate Affairs Commission, which was established by the Companies and Allied Matters Act of 1990, which has been amended severally. And the recent amendment is the 2020 amendment that has generated a lot of controversy. So, the Corporate Affairs Commission is the regulatory agency in charge of registration and regulation of business and non-business organizations, such as companies, business names, and incorporated trustees, as I said earlier. By virtue of Section 7, Sub 1 of CAMA 2020, what are the functions of CAC? So CAC is there to regulate. One of the functions of CAC is to regulate how companies are being run in Nigeria, supervise. They also supervise the formation of companies. So if you have a business right now, you want to register it, it's the CAC you approach, because they are the ones that will supervise the formation and will will incorporate the company. That's why we have incorporation here as one of the function of CAC. After incorporation, there's also filings you need to do, like filing of your annual returns. These are things, if to indicate to CAC that your business is a going concern, your business is functioning. You need to be filing annual. So and management of these companies and the rest, they will maintain a registry for you for that purpose. That's why we have maintain a company's registry in all states of the federation. If you want to do change of directors, change of shareholders, change of address, these are things you must file with the CAC, and there's a registry for your company in the CAC. So if any other person needs record of your company, he will approach the CAC and say, I want to know who are the directors in this company. I want to know who are the So these records are there for people to check. Then it is also the power of CAC to carry out investigation into the affairs of the company if the situation demands. While incorporating either a company business name, incorporated trustee, you have to give CAC the object. What is it you want to use this company for? What is it you want to use this church for? So by the time you begin to deviate from the object, the CAC has power to come and investigate. After investigation, they will have where the situation warrants, they will institute an action in court, obtain court order. They will give you opportunity to defend yourself too in court, obtain court order for them to take over to take over the management of that company. So that is why this scammer have generated recently past scammer has generated a lot of controversy, especially with churches, when they said CAC will take over the management of churches where the churches are not are deviating from their objects. No, it's not that CAC will just go and take over. They will institute an action in court after their investigation at the Federal High Court. Then they will give you opportunity to also defend yourself, your company, or your church before such orders are made. Then let's look at the Federal Inland Revenue Service. The Federal Inland Revenue Service used to be an arm of the Federal Board of Inland Revenue. So it was just an arm of the Federal Board of Inland Revenue. However, over time, they felt there was need to make the FIRS an autonomous organ from the FIBR. So by virtue of the 2007 Act, the FIRS was made an autonomous organ. So what is the role of the FIRS? FIRS is the federal government agency in charge of the collection and administration of federal and corporate taxes. And by virtue of Section 2 of the Act establishing the FIRS, it also has the function to control and administer the different tax laws in Nigeria specified in first schedule of the Act. And aside that, by virtue of Section 25 of the Act establishing the FIRS also have the powers to administer and ensure the enforcement of the various tax laws and enactments we have in Nigeria. And when we talk of these various tax laws and enactments we have in Nigeria, what are we talking about? We're talking about the Value Added Tax Act. We're talking about the Personal Income Tax Act. We're talking about the Companies Income Tax Act. We're talking about the Stamp Duty Act. The Stamp Duty Act. All these are there is there for FIRS to ensure that there is enforcement of this tax law. But for the purpose of this class and for the fact that most people are going into either the business of buying or business of selling and maybe providing services to people. So what will concentrate more on the value added tax. When we talk of the value added tax, we are talking of tax VAT, and VAT is basically a consumption tax that is levied repeatedly on a product or service that is being offered to consumers. That is why today, for instance, if you make a call, you will see they will charge you for VAT. You make another call, they will charge you for VAT because it's repeatedly being levied on you. It's something that is levied repeatedly on you. When you go to buy a product in the supermarket, let's say you buy a can of tin tomato today, you will see VAT included. Tomorrow you go and buy, you see VAT included. And you are aware that federal government recent, I guess, is it middle of this year, that they increased the VAT from 5% to 7%. So that has a ripple effect on the price of products in the market. So because you don't expect suppliers to be paying, VAT used to be 5%, and VAT, any person selling anything is collecting VAT for the federal government, on behalf of the federal government from the consumers. So once you are running a business, you need to register VAT with your local VAT office, which is any FIRS office closest to you, where you'll be given a VAT registration number. And it's true that you get to be remitting your VAT, which you are collecting for the federal government through your local VAT office. So it's something you might decide to be remitting uh, weekly, monthly, depending on the arrangement you have with your local VAT office. Then it's not all products that are vatable, as you can see on the last part of the slide. There are some cultivation of unprocessed agricultural produce are exempted from VAT. And of recent, I heard that the federal government are trying to amend the Finance Act again to exempt minimum wage earners from paying tax. So I don't know the idea behind that. So, but they did not say people that are into business. They said people who are earning minimum wage. So you are exempted from. They are working on exempting people from paying tax. But if you are into the buying and selling, you are into by selling products to consumers, or you are offering a particular service to consumers right now, you need to be remitting your VAT, because we will subsequently look at why it's important for you to do that in our subsequent topics that we'll be talking. Then let's quickly look at registration with Standard Organization of Nigeria. So when we talk of the Standard Organization of Nigeria, we're talking about a solitary body that is vested with the responsibility of standardizing and regulating the quality of products. Sorry for putting, it's not all products that are being managed by, that are being regulated or standardized by uh, Standard Organization of Nigeria. So I need to correct my slide, because we look at, there are inventory of products that are meant for Standard Organization of Nigeria. There are inventory of products that are meant for NAFDAC to 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 regulate. So it's not all products. So normally, if you go to Standard Organization, their website, you get to see the inventory of products that are meant to be standardized or regulated by the Standard Organization of Nigeria. So, what are some of the functions of Standard Organization of Nigeria? So, some of the function of the Standard of Organization of Nigeria includes uh, to investigate the quality of facilities, materials, and products in Nigeria, to ensure reference standards for calibration, to compile an inventory of products requiring standardization, what I said. So to foster interest in the recommendation and maintenance of acceptable standards by industry and the general public, to register and regulate standard marks and specification, like things like measurement tapes and the rest, to advise states and federal departments of government on specific problems relating to standards, to advise state and federal departments of government on specific problems relating to standard. The Standard Organization of Nigeria also, it has the powers to of seizure and classification destruction of substandard products. So once you get the slides, you get to see the functions of SON. So what are the procedure of registration? How do you register with Standard Organization of Nigeria? So basically, the Standard Organization registration with Standard Organization of Nigeria is into two. We have the e-product registration for imported and locally manufactured products. Then we have the mandatory conformity assessment program, which they refer to as MANCAP. So once you go to their website, and the product you want to import or you are manufacturing locally falls within the inventory of products that are administered by Sun, you first of all go to the Sun portal. As you can see on the slide, you click on e-product registration, then you continue. For a new company registration, you click on new account, you enter the business name or the RC of the company, a valid email address, just for you to register and for you to create a page. Then you go to sign in page and enter the RC number, email address, and password. The next page requires you fill in the company details. After doing it, you click continue. A payment advice will be issued to you. Either you want to do bank payment or you want to proceed with cards payment, whichever you choose. Choose the most convenient method for yourself of payment. After you've made payment, then you click on and impute payment details. So after you've submitted, once you go to the site, because if we say we are going, the inventory of products that are meant to be supervised or regulated by SON are so much that we cannot pick one after the other and be discussing. So once you go to the site, especially when it comes to the product registration, you get to pick what product you want to register, because they will bring out products within their inventory for you to choose. So depending on anyone you choose, then you fill the form and the rest. And there are documents you are expected to they expect you to scan and upload the following documents in JPEG or PDF formats at less than 30 kilobytes, like your CAC certificate, picture of the product, power of attorney if you are an importer. Power of attorney is just a document authorizing you to either import the manufacturer of that product is authorizing you to either import the product or to manufacture it locally in Nigeria. Then trademark certificate. You have to go to the trademark patent trademark registry of the Federal Ministry of Commerce here in Abuja or in your state of resident to obtain your trademark certificate. All these things, there are professionals available. If you feel this is too much work, I can't do it, there are people that are professionals that are available that can help you with it and will help you see, especially lawyers, especially with the trademark and any other things. We will discuss that too subsequently, especially when we come to do registration with CAC. We'll discuss agents available, though lawyers do most of these registrations for people. So that's just it on the product registration. Then we have the mandatory conformity assessment program. The mandatory conformity assessment program, MANCAP, is a mandatory product certification scheme put in place by SON to ensure that all locally manufactured products in the country conform with the relevant industry standards. So this one is just meant for locally manufactured products. So if you want to do this, you are into manufacture of products here in Nigeria, then you need to do this assessment by Standard Organization of Nigeria. So before such products are presented for sale in the market or exported. So the procedure for mandatory confirmatory assessment program involves inspection of the production process by SON, sampling and testing of the product against relevant Nigerian industrial standards to conform with compliance through conformity assessment, report of inspection and tells result. So these are things that SON will conduct to ensure that yes, these products you are manufacturing locally conform with all these things. And markup logo will be fixed on the smallest unit pack of the product, after which the product must undergo recertification. The markup logo is to be fixed on the smallest and the rest. So these are things that some will do to ensure that these products that are manufactured locally are of standard. They meet the Nigeria industrial standards. Then there's also this conformity assessment programs um, that was recently developed by Standard Organization of Nigeria, which is known as the Standard Organization of Nigeria Conformity Assessment Program for goods shipped to Nigeria. So it's also, if you want to ship into goods from abroad, there is also this conformity assessment program that has to be done by SON for you to distribute or sell your products in Nigeria. So basically, for details on all that, on the procedure of registration with Standard Organization of Nigeria, you could just log on to www.618biz.com, or you could just Google e-registration or product registration with Standard Organization of Nigeria. You get to see more, you get to see the procedure. Then for export, for the SONCAP, which is the Standard Organization of Nigeria Conformity Assessment Program, you can check um, www.cotina .com. So this is it, www.cotina.com, or you could Google export guides to Nigeria. So you get to see the inventory of products that you need to certify or standardize with some before you can start distribution of this product in Nigeria. You know, when you fail to standardize or certify such products, what you risk is consification of your product, because you know one of the functions of SON is classification and destruction of substandard products, including powers to seal up premises where defective products are manufactured or stored. So they normally carry out routine inspection in markets with security agencies. So once your product is of substandard nature, they'll just confiscate it and destroy it. So now let's look at registration with NAFDAC. Registration with NAFDAC. As I said earlier while discussing Standard Organization of Nigeria, I said it's not all products, contrary to what is contained in my slide. It's not all products. Rather, NAFDAC has the mandate of controlling, maintaining the distribution, advertising, exportation, importation, manufacture, the registration of categories of products such as food, drugs, medical devices, and cosmetics, etc. So once you are dealing with food, drugs, medical devices, these are things you are to approach NAFDAC for certification, not Standard Organization of Nigeria. Because NAFDAC, the Act establishing NAFDAC is so clear that these are when you are dealing with food and water, drugs and medical devices, herbals and cosmetics, vaccines and biologics, chemicals, veterinary products, and narcotics. These are things you should approach NAFDAC for certification to be issued with NAFDAC registration number. All businesses dealing in food and related products are subject to regulation by NAFDAC, as it is unlawful to market any drugs or consumable goods in Nigeria to the public without registration with NAFDAC. So you know over time it has been built in our subconscious that if we're buying stuffs like this food, water, drugs, cosmetics, and the rest, we tend to check, oh, is there NAFDAC registration number? And once there is no NAFDAC registration number on it, we tend to frown at it. To buy it will be discouraged because there's no NAFDAC registration number on it. So once you are into the food and water, drugs and medical devices, herbals and cosmetics, vaccine and biologics, chemicals, veterinary products, then you need to register with NAFDAC. Because once you don't register, you are attracting, you are just saying you want low patronage. So though then we'll look at the procedure for registration with NAFDAC, and we cannot pick every, because you know the procedure for registration is not similar across all boards for this category of products, because you have food and water, you have the procedure for its own registration. You have drugs and medical devices, you have its own procedure for its registration. You have herbals and cosmetics and the rest. They all registration. Though the documentation may vary for different drugs and food categories, the general registration procedure is similar and is broadly in two stages. First is application to bring in samples. That is if you want to import, not that you want to locally manufacture the product. Then full application after you've brought in samples for NAFDAC to inspect, or they've gone to inspect your manufacturing plant and the rest. Then you do your application, full application. So what we'll do right now, we are going to look at what are the key requirements? What are those documents you need to submit to NAFDAC? Let's say, for instance, you want to get approval or get NAFDAC registration number for you to be able to distribute or export or import or manufacture your drug in Nigeria. What are those key requirements you need? So we just pick some of the key requirements and discuss them in today's lecture. As I said, it's not something we can exhaust. I don't think we can exhaust everything. Even if we take the whole of this week, we can't exhaust everything, all the methods. So for general inquiries and everything, you could either go to NAFDAC website, or you could go to their office at Zone 7. If you feel you are feeling lazy to do that, you could engage an agent, which you will pay for his professional service, and he will do the running around for you. But you definitely have to pay him for his professional fees and the rest. So, what are those key requirements you need? Let's say you want to register drugs, you want to obtain NAFDA registration number for your drugs, or you have drugs you want to distribute, you have drugs you want to import, you have drugs you want to sell in Nigeria. So first of all, application is on a single product basis. When we say single product basis, basically we're saying if you have medicine for headache and that of stomach ache, you cannot apply to NAFDAC to be issued with similar medicine for stomach ache. Rather, you apply separately for the medicine meant for headache and separately for the medicine meant for uh, stomach ache. That is why they say application is on a single product basis. Then there's written application stating the name of the manufacturer. Let's say you are importing, you state the name of the manufacturer, or you are the manufacturer and you have a company, you state the name of the manufacturer and brand applicable. Then you complete the NAFDA application form. Then if it is a company, you the certificate of incorporation to the Corporate Affairs Commission, then you have to include it in your application. Then 5 copies of the product dossier. When we say 5 copies of the product dossier, definitely before you arrived at that particular drug or before you manufactured the drug, you must have carried out some analysis, some documentation, some, like for instance now the COVID vaccine they are working on. We have Pfizer, we have AstraZeneca, some companies and other companies. Definitely, you see them carrying out analysis, tests, trial stage. So all these things are the copies of product dossier you need to submit to NAFDAC for your product to be approved and registration number issued to you. 3 packs of the product sample, then notarized original copy of duly executed power of attorney from the product manufacturer. So as I said earlier, power of attorney is simply a document authorizing you to either import that particular drug or to manufacture it in Nigeria. So that particular document authorizing you to either manufacture the drug in Nigeria or import it must be notarized. And notarization is simply like a stamp and a special signature by a notary public, maybe in the High Commission in Nigeria, there in the country where the product is being manufactured. In the absence of the Nigerian High Commission, if it is a Commonwealth country, embassy, and if it's not a Commonwealth country, it's embassy you approach. In the absence of a Nigerian embassy or High Commission, then you can approach any British High Commission or ECOWAS High Commission uh, for them to ECOWAS country mission for them to authenticate that particular power of attorney or certificate of manufacture, either way, or a contract manufacturing agreement. It's either you want to go into the local production of that product in Nigeria, so you definitely have to sign an agreement with the manufacturing company that, okay, so that is that agreement now that you need to notarize, or is it they are giving you power to just import? You don't have the power to manufacture. you need to notarize that particular document, giving you the power. Then current World Health Organization Good Manufacturing Practice Certificate for the manufacturer authenticated by the Nigerian mission. We said NAFDAC is, even distribution, NAFDAC is in charge. So if you want to open pharmacy and distribute drugs, you need to obtain your license, you need to obtain something, permit from NAFDAC. That is why, aside obtaining your pharmaceutical or something from the Pharmaceutical Council of Nigeria, you need to also apply to NAFDAC to obtain one or two. So current superintendent pharmacist license to practice issued by the Pharmaceutical Council of Nigeria, premises registration license from the Pharmacist Council of Nigeria, certificate of registration of brand name with trademark registry in the Ministry of Commerce here in Nigeria. Well, you have to give them letter invitation. So generally, what I did here is I just mixed everything together. Let's say you want to run a pharmacy, so these are some of the requirements. But for details, contact NAFDAC, you get the details of, okay, what is it I need to get from NAFDAC for me to operate a successful pharmacy where I will not be disturbed by any NAFDAC staff that I failed to obtain this from them. Then you have certificate of registration of brand name with trademark registry in the Ministry of Commerce. If you don't have that, then if you intend to import that drug or anything, you must also give letter of invitation from the manufacturer for NAFDAC to go and inspect the factory abroad, and then you pay applicable fee and the rest. So there's also e-registration procedure for NAFDAC. So they call it the NAFDAC Automated Administration and Monitoring System, NAPAMS. So once you go to www.napams.org, once you sign up and register an account as a client, after signing in or logging in with your registered account, you choose the category of product, you log in again, category of product you want to register, preconditions made for registration, uh, especially when importing. You must have met all preconditions before filling the form. The complete your application form. These forms these are forms that one will ordinarily fill up manually before the introduction of the e-registration system. And the e-registration system and the manual system are being run simultaneously, because it's not something that has been in place for long. It was just recently introduced by NAFDAC. I can't tell how effective it is, but uh, it's a new procedure. They are trying to ease how people apply or register their product with NAFDAC. The processing the application, you obtain your certificate. So uh, basically, we are done with the relevant regulatory agencies for the purpose of this class. These are the regulatory agencies we've considered for the purpose of this class, and I believe you have an idea of what what are the functions and roles of these uh, regulatory agencies. So now we are going to talk about different business organizations and their legal implications, the types of business organizations and their legal implications. So when we talk of business organizations, we're talking of legitimate venture to make profit. Look at it says the key word there is legitimate. So anybody that is doing an illegitimate thing, you can't say that person is running a business organization, because what is a business organization is legitimate venture to make profit. Legitimate venture to make profit. What are the types of business organization? We have the sole proprietorship, we have the partnership, and we have the company. So I will discuss this now in details. As the name implies, sole proprietorship. Sole proprietorship. Sole owner of a business. Sole owner of a business, taking his decision alone, enjoying his profits alone, running his business without answering anybody. That's sole proprietorship for you. He is the alpha and omega of his business. If the business, if he likes, he comes to work. If he likes, he opens his business. If he like, he does anything. But what are the legal implications when you decide to run such sole proprietorship? When you are just running a sole proprietorship and it's not a company, neither is it a partnership. What are the legal implications? One of the legal implications is that as a sole owner of the business, you have an unlimited liability. Mr. Johnson is running Johnson Business Venture, just using Mr. Johnson and Mr. Johnson as an example. And the name of his business is Johnson Business Venture. He's the sole owner. He takes the decision alone. He enjoys the profit alone. He, as the name implies, sole owner. He does everything alone without consulting anybody. So what happens now when he runs into debt? The liabilities are unlimited. That means anything he does or any loan he collects or any transaction he does and he fails to honor that transaction or to pay back that money, what it means is that the persons he's indebted to, they will come after him personally. They will come after him personally. They will come for his car or his personal belongings, his beddings, his kitchen utensils and the rest. Anything they can find to offset their debt. So that is the legal implication of running a sole proprietorship. So right now, if you have a business and it's sole proprietorship, and you've borrowed money from banks and the rest, these are the legal implications. This is what you tend to suffer. You tend to suffer the embarrassment of them coming after you, your house, and the rest. So try as much as possible to avoid such scenario where you borrow money and you are unable to pay, that your debtors will come after you personally. That's the legal implication of running a sole proprietorship. The business, even if registered with CAC, is not a separate legal personality from the sole owner. Even though you are running a sole proprietorship and register it as business name with CAC, does not exempt you from that liability. You are personally liable. So when we look at partnership and company, you get to see what advantages are there for you when you decide to run partnership over sole proprietorship, especially company. You can be. We'll discuss that when we come to company. So this is the legal implication of running sole proprietorship. And as for partnership, partnership is basically where two or more people come together and decide to run a business together, sharing the profits together. So partnership can be limited and it can be general. We have limited partners and we have general partners. When we talk of limited partners, we are talking about partners that have decided that, okay, one of the partners or one or two of the partners have decided that they don't want to be involved in the day-to-day running of the business. Let me use this example. Mr. Johnson and Mr. John decide to enter into a partnership. And Mr. Johnson approaches Mr. John and told me, I said to Mr. John that, okay, I want to go into partnership with you, but I don't want to be involved in the day-to-day running of the business. I just want to be a limited partner. I just want to invest. That's just what I want to do. I just want to invest, sit back, give me back my investment, we share the profits. So in this case, Mr. Johnson is a limited partner. The general partners, on the other hand, is when Mr. John and Mr. Johnson decide that, okay, they want to run partnership, but both partners will be actively involved in the running of the day-to-day business. It's not just one of the partners investing and sitting back while the other partner runs the business for them. In general partnership, they are into the running of the business together. So general partners, if you are a general partner or you decide, when Mr. John and Mr. Johnson decide to run partnership, they are at risk of having their personal belongings seized because they are personally liable for any debt. So they are at risk of having their personal belongings seized to offset the debt and liabilities of the partnership business because it's a business made up of two or more partners, each sharing the business debt, liabilities, and assets. So, because of that decisions they made while entering into the partnership that they want to be general partners to be involved in the day-to-day running. So, they are personally liable for any debt. Also, limited partnership exists, but in the case of limited partnership, which exists when two or more partners go into the business, but one or more of the partners are only liable up to the amount of the investment. When Mr. Johnson approached Mr. John and told him that he just wants to be he just wants to invest. So in that case, Mr. Johnson is only liable to the extent of his investment in the business. So let's say Mr. John borrows money from a bank and the bank is unable to repay and the bank is now coming for his loan. For Mr. Johnson, it is only his investment in their partnership that the bank will go after. While for Mr. Johnson, Mr. John, who is involved in the day-to-day running of the business, they will go after his personal stuffs because he's personally liable, his personal belongings, his cars, his beddings, his kitchen utensils, anything of value that they can use, his gold chain, gold wristwatch, diamond ring for his wife, anything of his that is of value that can offset the debt, they will go after it. Then, that's just the difference between limited partners and general partners. Except expressly agreed otherwise, profits are to be shared equally among partners. Except profits are to be, except parties decide otherwise. If you're running partnership, it because let's say you want to enter into partnership agreement, you definitely have an agreement that you enter into, like written agreement. So it will contain your terms of the agreement. So it's for parties. Normally, you have to share profit equally, except where you decide otherwise. So the determination of a partner is in a business whether the person partakes in profit sharing. You don't partake in profit sharing, whether equally or otherwise, you are not a partner in the business. Then let's look at company. There's something unique about company. Okay, there's what we call limited liability partnership. It was just recently introduced in the newcomer. Limited liability partnership operates like company. So once I discuss company, you will get to have an idea of how limited liability partnership operates too. It's called LLP, Limited Liability Partnership. So you have an idea of how limited liability partnership operates, basically on how once I talk about the companies. So with companies is unique. One thing with companies is that company is unique. If you decide to register a company, there's this demarcation, there's this veil that you've created between yourself and the company. Because in law, we have two types of persons. We have an artificial person and we have natural person. Artificial slash juristic. We have artificial person and then we have natural persons. Companies are regarded as artificial persons, while human beings are regarded as natural persons. So from the day you decide to register your company, from the day Mr. Johnson decides to register Johnson and Johnson Limited, and certificate of incorporation issued to Mr. Johnson on behalf of Johnson and Johnson Nigerian Limited. Johnson and Johnson Nigerian Limited is a separate legal entity from Mr. Johnson. In this case, Mr. Johnson is the natural person. Johnson and Johnson Nigerian Limited is the artificial person. And as an artificial person, Johnson and Johnson Nigeria Limited can do whatever Mr. Johnson can do in his personal as a natural person. So that is why here it is written that it is a separate human being of its own from its shareholder. The only thing Mr. Johnson can be in that company, in Johnson Nigeria Limited, is he can either be a shareholder or director. But the company as an artificial person can do what any other natural person can do. So shareholders of the company have limited liabilities. So like Mr. Johnson now, even though he was the one that initiated the company, initiated the idea, registered the company, paid for the registration, he's basically the promoter of the company before incorporation. After incorporation, what he can be just a shareholder or a director in the company, and his liabilities are only limited to his investment to his shares in the company. Because once you are registering company, you need to allot shares to shareholders. So personal asset of shareholders cannot be seized. His personal asset of Mr. Johnson cannot be seized, because anything that the company is going into, be it any business, be it any contract, be it borrowing, any financial transaction, the company will do it in its name, in Johnson and Johnson Nigeria Limited. So the company, being human being of its own, can do the following. One, it can buy and own properties, it can enter into contract, it can sue and be sued, it enjoys perpetual succession. So that's why you see some certificate of incorporate some was it that is issued by ages, statutory right of occupancy, certificate of occupancy, C of O. You see them carrying names of companies, because these companies in law are regarded as juristic persons. That means you can sue them, and they are artificial. That means they can own properties, they can buy and own properties, they can enter into contract, they can sue and be sued. They enjoy perpetual succession. That is why they live forever. Let's look at banks like First Bank that have been in existence for so many years. Are you telling me the shareholders, the directors that began First Bank are still alive? Definitely no, they are not alive. But because it's a company and it lives forever, shareholders will come and go, directors will come and go. So that is what, when you register a company, that is one of the things you enjoy. That's why I say company is very unique, and you can apply for loan in the name of the company. The registration of business and non-business organization. Why do you have to register your business? As we've spoken earlier, I said to you earlier, the Corporate Affairs Commission is responsible for registration of business organization and non-business organizations in Nigeria. So any business, whether small, large, in the long run benefit from corporate and fiscal product registration. So why do you need to register your business? Because there are some official financial transactions you can't carry out with banks. Let's say you want to borrow money from bank, you can't do it if your business is not registered. Let's say your business is not registered and you don't pay tax. Of recent, the federal government roll out some financial incentive programs for people running different businesses to aid to cushion the effect of the pandemic on businesses. So let's say your company is not registered and you don't pay tax. How do you get to enjoy from these incentives rolled out by federal government? So there is need for you to, if you are running a business now that is not registered, you need to register it. Not just don't just stop at registration. Ensure you file your annual returns. Aside filing your annual returns, you pay your taxes so that you can enjoy whatever thing the federal government is rolling out. Then you have registration for tax, also important for social responsibility, both from the legal and moral angle. So let's quickly look at small business startup procedure. You want to start up a business, and I know already some of you are already running a business, one or two business. Let's say, but let's presume you don't have a business and you want to start one. What are the things you need to do? You find a suitable business name to support your business idea. You identify a suitable business location. There must be a connection with the what you are offering for business and the name of your business. There must be this connection. you identify a suitable business location. I don't expect you to go where they are selling water. Let's say we have like 10 vendors that are selling sachet water. Then you decide to go into the business of distributing sachet water when you know that the competition is steep, except you have something special, something different that will make you appear different from the already existing vendors in that particular location. If not, I don't see why you go into similar business in the same location. After you've identified a suitable business location, you register the business name with the Corporate Affairs Commission. Make sure you choose a name that is easy to pronounce and remember. You, as discussed earlier, value added tax. Your value added tax is very important. You remit it to the federal government. If it is product that is within the category of NAFDAC or within the inventory of SON to be registered, then you need to register that so that you can attract the patronage you are supposed to attract in the market. So that's on small business startup procedure. Then let's quickly look at procedure of documents to be submitted to CAC when you want to register a business name. Having done this, you've gotten a name, you've gotten a name of the company, you've gotten a name of the business name, you've gotten a suitable location, you want to register with CAC. What are you supposed to do? That's what we are going to look at next. What you are supposed to do. What are the procedure and documents to be submitted to CAC for registration of a business name? After that of a business name, we'll also talk about that of company. So what are these, what is the procedure? What are the documents you need to submit to CAC for your company for registration of business name? First of all, let me point out something. If you want to register with the Corporate Affairs Commission, you can either use agents. There are accredited agents with the CAC. Then there, you as a proprietor of the business, you can log into CAC portal, register with them to enable you register your business name. I don't know whether you get what I'm saying. There are agents you can use, or you can decide to do it yourself. And how do you do it yourself? You log into CAC website, you go to where you register, you create an account. Once you create an account, they will allow you to register as a business owner. But it's not as easy as it might seem, because there are some procedures that if you don't do correctly, CC will query your application and you get frustrated. So once you've gotten the name you want, reservation on name of on the CAC portal, once you've gotten the name you want, there are some things you need to look out for before choosing a name. One, the name must not be a restricted name. That means the name must not be a name that is restricted. That means you cannot use that name unless you've obtained consent from CAC. And one, the name must not be in use. Second, and again, the name must not be similar to another name that is in use. And sometimes there are some phrases that you are not allowed to use, or some words that you are not allowed to use as name to for your business registration, like International Chamber of Commerce and the rest. These are things that you need procedure. Or Abuja, you need to obtain consent of AMAC before you attach Abuja to any of the names you intend to use. So let's say you've gotten a name, a suitable name you want to register with, you've gotten the name. The next step is for you to go and impute that name on your portal. That's what we call reservation of name on CC portal. You go and reserve the name. Our names are reserved normally for 60 days. So once the name is approved, it will be reserved for you for 60 days until payment. Because once you reserve the name, you will be issued with a code. That code is what you proceed with to do your application. So once you insert the code, there is a place you go and insert the code, then it will automatically bring out a page for you where you have to carry out your registration, and the form is there for you to fill. It will ask you name of the proprietors, you need means of identification, you state the nature of the business. So after you filled the form, after filling the form, you download the form, then you sign, you attach passport of the uh, proprietors. Uh, then you pay. You pay before you can even download. Because after you filled the form, you pay the registration fee. For if payment, even for reservation of name, you have to pay. And in payment, you have to consider uh, remitter charges, because the platform the CAC uses for payment is remitter, and remitter will charge you for some charges. At reservation of name, they will charge you, CAC will charge you for that, and remitter will charge you also for that. When you are paying for the registration itself before you can download the forms, CAC will charge you for that, and remitter will also charge you for that. Then after you've paid, you can download the forms, you can sign, then you can upload together with evidence of your filing fees. Then example of business name are Tayo and Tayo and Co, Global Ventures Farms, etc. These are examples of business name. After you've uploaded, and CAC will go through, if there is no query, they'll send you an email with an RC number that your company has been approved, and go to so place to courier company to get your certificate of incorporation. So that is it on business name. So let's look at what are the procedure and documents to be submitted to CAC for registration of a company. I want to register a company with CAC. What are those things I need to submit to CAC? What are those things I need to do? Just like business name, you've gotten a suitable name, you've gotten an idea of the kind of company you want to run. But in the case of companies, we have different types of companies. We have private limited companies, we have public limited companies, we have unlimited companies, we have companies limited by guarantee. But for the purpose of this class, we are just going to limit ourselves to private limited company and public limited company, and most especially private limited company. And going by KAMA, the KAMA of 2020, with one shareholder and one director, you can register a company. Just you as one shareholder, you can register a company, and you as the only director, you can register a company. So this um, requirement I have right now of for 2 to 50 shareholders is no longer applicable. Then 2 to unlimited numbers of shareholders is no longer applicable for private limited companies, because by the new KAMA 2020, it says one person can be a shareholder in the company, one person can be a director in the company. However, the CAC are yet to begin implementation of the new KAMA. They are still applying the old KAMA. They recently released a circular that by January 2021, they will begin uh, uh, they will begin application of the new KAMA. So you get to register as one director and one shareholder. But as for now, if you want to register a private limited company, you must have at least two directors and at least two shareholders. Two directors, you and another person, and you and another person as a shareholder in the company. So uh, private limited company is suitable for small and medium businesses. And for the purpose of this class, a majority of you in this class, I believe you are running a private limited, you are running small business. So the most ideal company you have to register is the private limited company, because public companies are mostly big companies and they are quoted on the stock exchange. The fact that you start with a private limited company does not mean the company will not grow over time, that you will want to upgrade to public limited company. Let's say you started as a private limited company, a small company, and your name has acquired a reputation the trademark and the trade name is well known in Nigeria and you don't want to give up the name, what you will simply do is you just upgrade to a public limited company with this corporate affairs commission. So it's no big deal. So after you've decided that you want to do your private limited company, just like the business name I discussed earlier, you choose a name that is not in use, not similar, not carrying words. Because by the time you want to impute that name on CAC portal, be it you as a director of the company, because just like business name too, in company too, you, if you are the director of the company, you can register yourself if you are going to be among the directors. But where you will not be a director in that company, you cannot say you want to register for somebody. That can only be done by agents. And who are the agents that are accredited by CAC? They are lawyers, chartered accountants, and chartered secretaries. These are persons that can apply to CAC to be appointed as accredited agents. And these accredited agents have their designated portal. So then they can register for anybody. So in case you are finding it difficult or you don't have the strength, say you want to register yourself, you could just contact any accredited agent, a lawyer, chartered accountant, or chartered secretary who is accredited with the CAC. Because if you are accredited with the CAC, you'll be given an ID card to that effect. If I had come with mine, I would have shown you to that effect that you are an accredited agent with the CAC and you can register uh, on behalf of someone. So you enter the name. After you enter the name, notice of approval will be given to you that the name has been approved and reserved for 60 days. So it's within that 60 days, you need to fill your forms and make payment. Once you make payment, you don't stand a chance of losing that name. It does not expire. So once you do is you complete a set of your incorporation forms detailing personal information, proposed director, shareholder. Company must have a minimum of two directors and two shareholders, as I've said earlier. So you enter their details, means of identification, secretary of the company, what are the objects of the company as it will be contained in the memorandum of understanding. Okay, sorry, memorandum of association. Then you have the articles of associations too, duly stamped. All these things are things you feel while filling the form. Then you have what we call share capital of the company, which is for smaller companies. Even though in Kama you see private limited companies 10,000, public is 50,000. But these are things that Kama has given CEC the power to change. So the minimum share capital CEC will take is 1 million share capital for private limited company. And when I say 1 million share capital, I'm not saying you pay CAC 1 million share capital. It's just an artificial valuation of your company. That your company is worth 1 million share capital and you intend to share the 1 million shares between your various shareholders. So after you filled the form, you've done that, you've made payment, you download the form for the directors and the secretaries and the shareholders to sign. It's possible you have different directors, it's possible you have different shareholders, it's possible that the same directors are the same shareholders. So anything you download, you you make your payment. So this is just fee registration of companies. So after you make your payment, you upload the documents to CAC. CAC will look at because there's a procedure for uploading it. If you don't do it correctly, they will query it and your company will not be incorporated. So where you think you find it difficult to do such, you can just contact an agent. An agent is used to doing these things, so he will just do it for you, and you pay him his professional fee for that. Then once you upload your documents and CAC will go through it, if there is no any problem, they will not query it. They will issue you with RC number. Then later on, they will call you and they will tell you where to go and pick up your certificate. The courier company will go and pick up your certificate, which you also pay them before picking up your certificate. So that's it on procedure and documents to be submitted to CAC for registration of the company. So what we have here is just a sample. It's not like what is obtainable right now when you want to register a company. It's just for you to have an idea of how much you need. Because as I told you already, private companies are 1 million share capital, and believe me, the fees to be paid is not 10,000 naira for registration right now with CC, because you have to put into consideration uh, uh, stamp duty, remitter charges, and the rest. So you have to put all this into consideration. So this one is just here for to give participants an idea of like registration of business name, change of name, business name search, and the rest, just to give participants an idea of how much the fees are. Once you want to do any work, you contact a professional, you contact anyone, you get to know the amount of how much you will be charged for any work. Then finally, we are going to, yeah, this is our final topic for today: law of contract. Even though law of contract on its own is a course. It's a course. Law of contract, the Nigerian textbook alone, if you see the Nigerian textbook on law of contract, you know that it's not something that should be finished within 10 minutes or 30 minutes. So it's just to give you an idea of what law of contract is. That's why we are putting this that's why I have this topic here, law of contract. That's why we have this topic here, law of contract. Because once you register a company, what you'll be going into is buying and selling. You're you are either you're entering into a contract. By selling, you are entering into a contract. By offering a service, you are entering into a contract. So you need to have an idea of what is it I'm doing, what are the implications of what I'm entering into. Can I say this thing that I've entered into is a contract? So when we talk of contract, we're talking of an enforceable legal obligation agreed upon by parties. There must be consensus between parties that you want to enter into a contract. So the features of a valid contract. What are the features of a valid contract? What do we need to look at to say that we have a valid contract? One, there must be offer. Two, there must be acceptance. Three, there must be consideration. These are the basic elements in a contract: offer, acceptance, consideration. When can we say there is an offer? Let me give you, offer can take different uh, how will I put it, different perspective. Let's say in the first instance, the offer I know all of you are aware of is me approaching you and telling you I have something for sale. That's me offering something for you. Mr. Johnson has a car, a Mercedes Benz. He approaches Mr. Johnson that he wants to sell that Mercedes Benz to him. That's offer. But there can be offer in another way. Offer can be such that uh, offer can be such that where you go to supermarkets, you see them displaying products on their shelf. So that products they are displaying on the shelf, that's invitation to treat. Once you pick that product and go to the cashier, you by taking that product to the cashier, you are making an offer to the cashier. Then it's left for the cashier to accept your offer by accepting your money. There can be offer. Offer too can also take this can be in this way too, where you see advertisement of invitation to tender. You see government ministry calling for an invitation to tender, in that they are calling on contractors to submit their applications and their quotations. So the contractor submitting that is also an offer. So in law, these are things we regard as offer. So once they accept your offer, then you guys have made a step in the contract. Then there's what we call consideration. Consideration is when a thing of value has exchanged, and when there is money, when you exchange money with the person, then there is said to be contract. Once there is offer, acceptance, consideration. Mm, Mr. Johnson made an offer. Mr. John accepted that he wants to buy the Mercedes Benz. He gave him 50,000 naira for the Mercedes Benz. There's offer, acceptance, and consideration. So, what are the other elements you need to consider once you're entering into a contract? You need to consider the form of the contract. Sometimes some people mistaken the fact that contract is only when parties sit down and execute documents. No, contracts can be by conduct. That's why we have form here. It can also be by, it can be orally, and it can be written. So conduct, like you enter taxi sometimes without even telling the taxi where you are going to, without even negotiating price, because you know where the last bus stop is, and your intention is to stop at the last bus stop, and you know how much it is when you reach the last bus stop. So such kinds of contracts are by conduct. You are just entering such contracts by conduct. So orally, when parties agree orally, I want to sell my car to you and the rest, then all the offer acceptance and consideration thing happens. Then there's also a contract. Then let's look at capacity. When we're saying capacity, it's not everybody that has the capacity to enter into contract. Lunatics, persons who are mentally challenged, cannot be said to enter into contract at the time they are mentally challenged. Person who is drunk, at the time he's drunk, you cannot say he can enter into contract, because at that period he's mentally challenged, because he's not in his right senses. Minors cannot enter into contract. You cannot enter into a contract with a minor and say that that contract is valid, except where that contract you entered with that minor is for his necessity, those things he really needs. That is when such contracts are in law regarded as as valid. Then we have I call minors, mentally challenged persons. So once you enter into contract with these persons, your contract is not set to be valid, because at that period these people are not regarded as having the capacity to enter into a contract. Then we have legality. From the definition of contract, we said it must be an enforceable legal obligation. So any illegal activity like prostitution and the rest, these are not enforceable in court. Or where you hire people to go and steal ballot boxes in the name that you pay them 50,000 naira. Such people, if they are not paid that money, they cannot say they want to go to court and enforce such contract, because such things are illegal. And then there must be this intention to create legal obligation by parties. Parties must be willing that yes, they want to create a legal relationship between them. Then we have what we call privity of contract. Well, once I'm talking of privity of contract, I'm just saying that only parties to a contract can sue. Mr. Johnson wanted to sell his car to Mr. John. Then Mr. Johnson sold the car to Mr. John. Mr. John only paid 25,000 naira. 25,000 naira is yet to be balanced. So Mr. Johnson cannot go and sue Mr. John's wife, because Mr. John's wife is not party to that contract. The contract was between Mr. John and Mr. Johnson. So that is what privity of contract is saying. Privity of contract is just saying that only parties to a contract can sue. And Mr. Johnson's wife cannot sue Mr. John because he has failed to pay the balance of 25,000. Because only parties to a contract can sue. However, there are exceptions to that general rules. There are some contracts whereby even though you are not a party to that contract, you can sue. Let me just give you an example. It's covenants running with land. Let's say there is a covenant with the property that if you are entering into that property, you are not meant to erect the fence higher than 15 meters. Then when you entered, you did not erect the fence more than 15 meters, then you sold the property to another person. And when you sold that property to another person, he came and erected the fence within that estate above 15 meters. So in that case, the estate managers can sue that person, even though the contract they enter was with you. So this is an exception to privity to contract. And then we have terms of a contract. Terms of contract, it can be express or implied. Express in the sense that the terms are written vividly for parties to see. Everything is there. You cannot imply any term. So sometimes, though, it's difficult for parties to state every term in a contract expressly written for all the parties to see. In such case, certain terms can be implied. Mr. Johnson wants to sell his Mercedes to Mr. John. There is this presumption that everything at the time he was about to sell the Mercedes to Mr. John was in good condition. So even though it's not stated expressly, let's say they have a written agreement that they state that this is working, then they failed to state that the accelerator is must be in good condition. So it will be implied that at the time that he's selling that car to Mr. Johnson, to Mr. John, or Mr. Johnson to Mr. John, that accelerator must be in good condition. So these are terms that can imply. But in law, when you go to court, hardly do courts want to imply terms to what is agreed with parties. So I'm advising you, anytime you're entering into contracts, don't leave any term implied to be implied by state it expressly. Everything, no matter how bulky the contract would appear. Because every time you are drafting, you draft with the mindset that you end up in court. You might likely end up in court. And you should not be cheated when you end up in court. So then let's look at what are the elements that can vitiate a contract. What are those things that, even though is a contract, even though those elements we listed earlier, offer acceptance, consideration, form, capacity, legality, intention, are present, but are there to vitiate that contract. We have what we call duress, where you threaten a party to enter into a contract, physical threat of violence on another person, that he must enter into a contract. In such a case, such contracts will be vitiated because there was no intention there to create legal obligation. You forced it on him. So that's duress. You are telling him he must enter. And there is an English case that looked at duress from the economic perspective of duress, where you use economic duress on somebody. That means, let's say, uh, you hired some workers. You've already agreed with them that you are going to pay them 15 naira for the job. So in the course of doing the job, they've reached a stage that they know that if they don't complete that work, it's going to be detrimental to you. Then they will say they will not complete except you increase that money to 17 naira. So in that case, we have what we call economic duress. That contract will be vitiated by that actions of by the action of the laborers, by insisting that they will not continue except they are being paid higher amount. Then we have undue influence. Undue influence can exist where there is fiduciary relationship and when there is no fiduciary relationship. Fiduciary relationship exists whereby one of the parties has superior knowledge or holds a confidential position uh, somewhere that he can influence that other person's positions. Especially examples of fiduciary relationships like banker-customer relationship, lawyer-client, doctor-patient relationship. These are examples of fiduciary relationship. So you know these people, because you regard them as experts, they advise you. So they can influence your decision. So when they use that influence over you to take a decision that is undue to you and is unfair to you, in such a case, such contracts are not valid. They will be vitiated. So and undue influence can also exist where there is no special relationship, especially when, for instance, somebody closest to you is the person that commits a crime and they want to use that against you to make you to enter into a contract. In such a case, there is no relationship, but they want to use that particular act to influence you to enter into that contract. So in that case, there is no contract. The law, if you go to court, the law will interpret that as that contract as non-existing because there was an undue influence on you to enter into such contract. Then there's what we call misrepresentation. Misrepresentation is when you misrepresent facts about a particular subject matter of the contract before or at the time of entering the contract. Let's say Mr. Johnson, before entering the contract, will tell Mr. Johnson that this car is super, it's the mileage is 2,500 and something, that the tires are in good condition, but Mr. John has not seen the car. When he sees the car, he finds out that after making payment, all the things that Mr. Johnson said, he misrepresented the facts. In such a case, such contracts will not be valid. Then we have what we call mistake in law. Mistake in the sense that the subject matter of the contract is no longer in existence and is unknown to both parties, that at the time they were carrying out that negotiation, at the time they were making payment, the subject matter of the contract is no longer in existence. So in such a case, we will say there's a mutual there's a common mistake, because at the time they don't know that that subject matter, Mr. Johnson and Mr. John, they are discussing about sale of filling station in Gwagwalada. unknown to them that at the time that Mr. John was making payment, the filling station in Gongolada got burnt or was destroyed by a storm. So because the subject matter of the contract is no longer in existence, in such a case, such contracts are vitiated. There is what we call also mutual mistake. Mutual mistake in the sense that Mr. Johnson has two cars, BMW and Mercedes. He approaches Mr. John that I want to sell my BMW for 50, my Mercedes for 60. Mr. John thought he wants to sell the two for 50,000, then he pays 50,000. In that case, there is a mutual mistake as far the subject matter of the contract. So these are things that can vitiate a contract. Then what are those things that when can we say a contract is discharged? When can we say that parties have performed their obligation and contract has ended? You've entered into a contract with a party. When can you say that that particular contract has ended? Once there's performance. Once party A has performed his part, party B has performed his part, then there's contract. Then frustration. Once the subject matter is no longer in existence, remember the example of filling station I used, that such contract is said to be discharged by frustration. Then when there is a fundamental breach of the contract, let's say you ordered for an iPhone from Konga and Konga supplied you with HTC, that is a major breach. That's a fundamental breach of that contract, and by such contract is discharged because it's not what you ordered for you got. Then you have mutual agreement whereby parties can agree mutually to terminate their contract. So that's mutual agreement, and such contracts are terminated mutually. Then finally, let's look at remedies of breach of contract. What are the remedies for breach of contract? We have damages, which are monetary compensation, whereby as a result of breach by one of the parties, you've suffered financial loss or you've suffered some psychological loss. These are things, if it's something that can be compensated, uh, they can compensate you in monetary terms. The court will consider that and compensate you with damages, which is in monetary terms. And there's what we call specific performance. Specific performance is an equitable remedy. It is at the discretion of the court. The court will not grant such remedy when it thinks that damages will be sufficient remedy for you. Such a case, the court will not grant you specific performance. But there are instances whereby the courts will grant specific performance when it involves property, land. In that case, damages is not an option. It has to be specific performance. Then we have what we call ratification, where the courts will alter the terms of the contract, which is hardly done. Will alter, let's say Mr. Johnson is to supply 50 bags of granules to Mr. John. He ended up supplying 20 bags. The court will say, okay, since he has supplied 20 bags to you, why don't you just pay him for the 20 bags? Then so you see here the court is altering the contract of the parties. That's what we call ratification. Then we have what we call injunction. Injunction, that is stopping a party from doing something. Though law is somehow weird. Sometimes injunction can mean making a party to do something, but there's what we call mandatory injunction. Mandatory injunction making a party, but injunction generally means to stop a party, restrain another person from doing something. So it's a remedy available to you to stop a party from doing something. Then we have what we call quantum merit, which is reasonable value of service. You being rewarded according to the reasonable value of service you've offered so far. Let's say you are hired to build a three-story building. You've constructed up to the two-story building. Then suddenly the owner of the building says he doesn't want you to continue with the job. In that instance, it is normal for him to give you uh, it's normal for him to pay you for that services you've offered. So you can approach the court and say, okay, I've built this property to this level, so I'm entitled to so amount. So that's what we regard as quantum merit in law. Then we have what is called rescission. That is, the contract is totally rescinded. That is, the court is saying there is no longer a contract. You don't. One of the parties approaches the court and say he doesn't want the contract anymore. He wants the contract rescinded. So if he presents his case, then the contract will be rescinded. So that's it on today's class. Thank you very much. We're done for today's class. If you have any question, uh, contribution, or observation or comment you want to make, now is the time. Any question, contribution, comments you want to make is the time. You have any question you want to add, uh, you can unmute your mic, uh, ask your question. Now is the time for questions, observation. Unmute your mic and ask your questions. Now is the time. The field is open for anyone who has a question. I'm giving you like 3 minutes to do that. If you have any question, now is the time to ask. No questions? Okay, I'm about to round up. In the absence of any question, there will be a post quiz. After I'm done, they will post the post quiz down to the uh, 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 I'm seeing your comments on the chat. Thank you very much, Mr. Sunday. Thank you, Mr. Aluko. I'm grateful. So we've come to the end of today's class. So they are going to post they've already posted the quiz on the WhatsApp platform. So just go ahead and take the quiz so that we'll assess your understanding of today's lecture. And this is today is only one module, and we've come to the end of today's class. I believe the project manager will pass any information to you via the WhatsApp platform on graduation and other things that you need to know this night. So you get to have information. And I guess graduation will be tomorrow. So they will communicate that to you on the WhatsApp platform. So thank you very much. Thank you for your patience. I'm really grateful. So we've come to the end of today's class. Thank you.